So this panel will be dedicated to AI and data protection in the BRICS countries. We have been doing some work on this over the past years, especially on data protection in the BRICS. Last year in November, actually, I published a paper on the Oxford University Journal with Danilo Doneda on this. It is actually the first paper, the first academic paper that really starts to scope out what are the elements of innovation and differences, the different flavors of BRICS regulation of data protection. And it's very important for me, not only because it's something that I'm really investing a lot of time in exploring digital policies in the BRICS over the past 5 years of our Cyber BRICS project here at CTS FGV, but also because it's really something I was doing a lot with Danilo, that had a lot of conversation with us, provided a lot of input to our conversation. And now we are expanding somehow. So we are going to also have a book on data architectures in the BRICS that we hope to have published by the end of the year. And another one, there is an ongoing work on AI regulations in the BRICS that will likely become a book next year, but so far it's only a collective paper. To discuss what are the most interesting part of the data protection and AI regulations in the BRICS countries and how they interact and intersect, we have a very distinguished and large set of panelists. It's always necessary to have a large panelist with BRICS because it's at least 5 panelists because it's 5 countries. So in BRICS order, we'll start with Ligia Calvino that works for Huawei. She is in the data protection lead in the Latin American team. Then we will have from Russia, Ekaterina Martinova from the Moscow School of Economics. Then from India, Smriti Parshira, who is our Indian research fellow at the Cyber BRICS project. Then from China and Hong Kong University especially, we'll have Wei Wang, who also is the China part of our Cyber BRICS project. And of course, Ekaterina is the Russian part. And then last, but of course not least, we'll have Professor Sizwe Znail, who is professor at Nelson Mandela University and who was the former data protection regulator of South Africa. I propose we start following the BRICS order with Ligia, exploring a little bit of how these issues intersect and what is also Huawei's approach to these issues. Thank you very much for being with us, Ligia.
So thank you, Professor Luca, for this invitation. And I start apologizing myself because we have strong security measures and I couldn't be able here to send the presentation. But if later you can share, I hope you receive it because I spent a little time to make some beautiful PPT. So just to ground this discussion. And I will start here. Another disclaimer, okay? I'm not going to take the law perspective from a legal perspective because I'm not a lawyer, but what I want to bring here is more how Huawei has its governance on AI and privacy protection. And then I'm going to start with a very obvious question. Where is AI? It may seem a very simple answer. But for the society in a whole, sometimes they don't perceive it. We have AI for a long time already. We use that in the smart transportation, network optimization, mainly that it's our telecommunication area. And now the users are getting more, are experiencing the benefits of AI in autonomous driving and in smart retail. So now it's becoming a little easier to perceive really what AI is. And this is just a provocation because this will bring to all the challenges that we are facing. We can say that we have positive and negative, if I can say so here. And just to give a context on that, in AI, we still focus a lot on privacy. Privacy keeps to be a key concern in this digital society. And in the presentation, there was a video, very interesting one, because when we talk about personal data, it's easy to see some of the risks that now we are facing when we expose our data in the social medias, in the web. And they did an experiment in Brussels where they got some people from the street and they told them, oh, this is for a television program, come here. It was like a kind of guru. And then he started asking some questions to this person. And then, okay, your family name is, you have a son, a daughter, your bank account is this one, you spent $20 on clothes, everything about their personal life. And the people got very admired. Oh, how can they know so much data? And this voluntary or sometimes involuntary, we are sharing that data when we put some photos on any kind of application to see how we are going to look old. And we don't know what they are doing with our data. And with AI, that's why it brings this concern on AI, some unintended consequence that we can have in AI, especially for the individuals. We talk a lot about privacy and reputation, but we can also have negative impacts in the organizations and also for the society as a whole. When we see some other examples that I will talk a little bit more later. And the other picture that I brought here is that what is behind this complexity when we talk about artificial intelligence? I'm saying from a technical perspective, not from a law. I'm an engineer. Sometimes I look at the technical part. Okay, we have a box, but what is in that box? And mainly the industry defines two phases, the model training and the model inference. In the model training, we have the data processing. So the data is the core of AI. No matter if it's personal data for sensors that we are using in the network optimization for the BTS stations, for example, just to give you some realistic examples here. And when we do data processing, we transform data in an algorithm model. And then we started generating that model that will be used in several sectors of our industry. And the last phase here, when we have this trained model, and there's a lot of complexity, I'm being very briefly on that because I'm not also a data scientist to go deep. And this is one remark that I do here. That's why we need this multidisciplinary approach. We need to have a view from a legal perspective that we are having a lot, but we need to invite the industry, the specialists to come and say, oh, that model works that way, that algorithm that is generating data bias, it's because of this, maybe because we don't have high quality data, or maybe we have some other challenges that we are still trying to figure out. And then I want to position where Huawei is. Huawei is a technology provider. And later I will do this correlation with the data protection roles, just to be clear how many actors we have involved in this very complex scenario. And just to give an example of some AI system challenge, I was looking for data to a better example to say here. And then from IAPP, they published a study where some researchers were analyzing the deep learning, because the initial study was they had this deep learning to distinguish a husk from a wolf. And then they realized that the model was making some false correlations. And sometimes this is not easy to perceive. Oh, that's not a very simple algorithm. Sometimes we have that black box and we have a lot of opacity on that. So it's not a really real to understand the challenge that is. So what they meant with this study? They tried to distinguish this husk and this wolf, but they realized that the machine was trained. The machine had some inferences. Every time there was a snow, it was a wolf and not a husky. And then when they got the image from a husky in the snow, the system understood that it was a wolf and not a dog. And this is very complicated because when we see this kind of application in the autonomous driving, for example, when we had some experiences on that, I see a lot of people saying, yeah, we experienced an accident with Tesla some years ago where probably the machine was trained to understand that the road was without any roadblocks. And when they had a very serious accident that killed some people, the road was blocked. There was some construction. And then you see that some kind of very small inferences can lead to a very damaged situation. And this can be used in several ways here, like we are having a lot of discussion, at least is what I'm hearing, about deep fakes, the copyrights, the intellectual property, and I don't know, in the future, what the discussion will be. Maybe something that we are not at this moment realizing that could be discussed within the AI negative consequences. And then Huawei has an approach on that, on shared responsibility regulation. As I mentioned before, we understood our role as a technology provider. What it means technology provider, and then I'll break down this a little bit more later. When we have the consumers, the final consumer that we want to offer a service, of course, behind that we have the business deployer that need data, high quality data, as we discussed. For the data scientists and the application developers to use that data, making use of full stack AI. And this full stack AI is that we are going to break down because we have Huawei as a technology provider, we have the app developers, we have many roles that sometimes when we think about AI, we don't realize that it's so complex and may involve a lot of people on this ecosystem. And make a correlation with the data protection roles here. Of course, we need AI regulation on that. That's why we all here discussing that. And a strong data governance. This is the point that Huawei relies its privacy, cybersecurity framework based on a strong governance, because this technology provider will allow the data operator to process that data to the controller, and then the controller to provide the final service, the final product to the data subject. So in 2019, we had launched a white paper on that. There are several researchers from Huawei that later I'm going to share the links. I invite you all to take a look on that because it's very complete on AI security and also on this perspective of privacy protection. And breaking down a little bit this shared responsibility with these data protection roles, Huawei is in the networking layer, computing layer, and algorithm layer. So we make use of open source algorithms, and then coming up, we have the layers of the data layer, the real data that is going to be used in that model, and the application itself, who is going to develop that application. And then we have all the other layers here of the deployers, the data collectors, customers, and consumers. This is important when we read the law. We need to understand the role of each company there, because sometimes we get the law and say, okay, I'm what? I'm a processor, I'm a controller. And I think this was a question that we had in LGPD. Many companies or many people had, okay, if I'm dealing with data, directly with data, am I a controller? Am I a data processor? That's why ANPD launched a lot of guidelines to help people understand that. And also the regulated entities, how we can comply with the law if we cannot understand that. And then what kind of challenges we are trying to solve? We have challenges on the technical side. We may have lack of robustness of this model, and this may open doors for attacks. We have many kinds of attacks. I'm not go deep into that, but evasion attacks, poisoning attacks, backdoors, and so on, leading to this misclassification. We can kill people, we can kill someone if this misclassification makes an error on the medical dosage for that patient is very serious, a consequence. And in societal applications as well, we may have abuse of those AI services. We know that our society is unfairness. Sometimes the system just bring what we have. This is my conclusion, okay? My personal conclusion. The system just brings what we have normally in our day-to-day lives. Sometimes the facial recognition system will not recognize someone because of the skin tone, but maybe sometimes this person will also suffer any kind of discrimination without any system. So that's why we have to work on that societal side of view to avoid these kind of things, and also bias, for example, just give another example, bias credit analysis and so on. And from the legal aspect, of course, we need laws and regulations. We need someone to say, okay, you have a minimum requirement on that, to assign that responsibility. If an autonomous car kills someone, who is going to be blamed? The car, the system, who deployed the algorithm, who? So we have to make that clear on this aspect. And the data, I just mentioned before that the data is in the core central part of this AI, no matter it's personal or data itself. And that's why we have a strong security on AI when we talk about that, to avoid this kind of situations. And then we propose a 3 layers defense, because the security, everyone knows, that is made on layers, right? I had many layers here just to send to the PPT information, because we cannot use a USB, it's forbidden. I have to ask for control, many things here to protect the information, the confidentiality, the intellectual property of Huawei's information, for example. And in this AI security, we have, so our objective is to mitigate attacks, to protect that model and the architecture itself. And then what is our commitment to this AI security and privacy protection collaboration? Huawei has a lot of influential guidelines. We are one of the co-leaders of mitigation studies with ETSI. We participate in several research with ENISA. So this, a lot of you know that we invest a lot on research. This is a very important part of Huawei's work. And then if I can summarize here, we have 7 pillars on these governance objectives. The first one is the system security and controllability. So the system has to be reliable, adaptable. And then we go to the deployment objective assurance, where we have to meet the lawfulness requirements, the fairness, security, privacy protection, and no misuse. The competence is very important. We need to have people that know how to deal with such technology. As we have in the privacy side, many of our professionals are certified by IAPP, for example, just to give here a very simple analogy on that, but we need to have these people well-trained to deal with the system because of all the complexity that we have. The data management is another aspect. If we don't have a strong governance on data management, no matter what we do, if we have competence people, but we are not using high quality data, I can bring some bias, some wrong inferences to this model. So this is very important within our governance. Privacy protection speaks by itself, the fairness and the transparency and traceability of the system. As we saw in the law project, we shall be able to provide that explainability to the users. So that's why one of the pillars, one of the very important pillars. And just to close here, because we have a lot of discussions, I hope so. Huawei has published this AI security white paper and thinking ahead about AI security privacy protection that I'm going to share the link with you all. And we invite our customers, the academic to share their opinion. Huawei is open to this open collaboration on AI. And we have our transparency center. I think Huawei is one of the most transparent companies in the world. You know exactly why. So I invite you all to visit our cybersecurity and privacy protection center in China, Dongguan, and also we have a unit in Brussels.
Thank you very much, Ligia, for the very extensive introduction, and indeed I think that a collateral effect of the enormous scrutiny that regulators around the world had on Huawei over the past 5 years is that it has increased a lot the level of transparency and security, which is very interesting then to analyze now in terms of AI and how you already have developed a governance approach to AI. Switching from China to Russia, where President Putin hit the headlines in 2019, claiming that who controls AI will control the world. We can start to have an understanding of which kind of normative approach has been developed, which is very much focused into digital sovereignty or internet sovereignty. And Ekaterina, we have your presentation here. Do you want me to share it? Yes.
Thank you. Thank you, Professor. I will take my time, a couple of minutes, some minutes, to give some brief description on the current AI and automated personal data processing regulation in Russia. So yes, the first slide, please. The next one. Okay, then the previous one, please. Sorry for that. Yes, it's just some, it's good.
Everyone can see here. It's there. So, you know what? I think that the problem is that let me have a moment of reflection with you about the high level of technology of a foundation where we are now, but I will not mention because we are recorded. But in the Zoom version, we have PPT doesn't work properly, but PDF does. So may I use the PDF version of your?
Sure. Yes.
While you present. Sorry.
Okay. Okay, I will start then. We do not have a comprehensive one piece of federal, one piece of federal law on the AI yet, but still we have a lot of regulation actually, and as may be seen on the next slide, according to the Stanford AI survey, yes, as a result of 2022, Russia was the #2 jurisdiction after the US on the number of acts, legislative acts related to the AI. So actually we have some pieces of regulation in different sectors. And the main piece is the national strategy on the development of the AI. And we have also the concept of the development, which are not pieces of federal legislation, but rather some governmental and presidential acts, but still they are like programming acts introducing the framework of future regulation and also the approaches of the Russian legislator to this very intensively developing field. And we have a federal law which introduces an experimental zone in Moscow, particularly about introducing AI in different fields of public and private services. And I will give an example in the end of my speech. So on the federal level, mainly we have this piece, introducing this sandbox experimental zone in Moscow, and some other pieces of regulation on the level of national strategy and the concept. So yes, the next slide, please. So let's see what is the AI in the understanding of the Russian legislator. At the stage when the national strategy was developing, there were debates on how to, not only how to regulate, but also how to understand what the AI is. And finally, what was implemented is the human-oriented approach, so not the technical one, but the AI is understood as the solutions which allow simulating human cognitive functions, and the results of the simulating of the tasks should be at least comparable to the results of human intellectual activity. So this is the approach introduced, is this comparison of how the AI can be compared to the human intellectual activity. So the strategy introduces key principles for the regulation, and the first one is not maybe as they named in the strategy, because it was adopted in 2019, but now obviously we cannot ignore the elephant in the room. The sovereignty principle is the key one, the central. So under the sanctions pressure, the country aims to decrease dependence on foreign technological solutions and to rely mostly on the domestic software and hardware and technologies, and in the field of AI particularly. Also, the principle of the integrity of the research and development and real sectors of economy, because the approach is very practical, very results oriented. So all the discussions also include representatives of different sectors, aiming to understand what the pain of the particular industry and to maybe to suggest solutions based on the AI technology. Also, the risk-based approach oriented on the reducing of harm to participants of public relations, to individuals in different sectors, including some restrictive regulation when there is risk of harm, for example, to the labor protection norms or intellectual property, and support for competition, because we aim to create such market which will allow different participants to suggest their solutions, and it is implemented in the Moscow experiment, which I will come up in a minute. So looking at the automated data processing, I should say that this is the task ahead for the Russian legislator to develop norms regulating it, because now we have only like a saving clause in the federal law on data protection, saying just that decisions which lead to legal consequences for a person cannot be based only on automated data processing, meaning that a decision, for example, on criminal conviction, on sentencing, administrative process, etc., so which actually leads to diverse legal consequences for a person, now cannot be based solely on the automated data processing. But again, it is a saving clause, so no expanded regulation yet. Although in the strategy we have this aim to develop by 2030 such a volume of data, which will allow also development of automated data processing based on the AI technologies. And finally, the experimental zone in Moscow, yes, the most interesting part. Yes, the federal law allows some municipal regional amendments, particularly in Moscow, because of this regulatory sandbox. And it is implemented in different fields, like self-driving vehicles, which you can see in some particular districts of Moscow. And but I will tell you very briefly about another experiment, which is the AI experiment in the healthcare system of Moscow, which was launched in 2020. And you can see the results as of yesterday, because they publish it like in the real life time frame, and this is the results on the 19th of July this year. So what is the experiment? The software developers, companies suggesting AI solutions can participate in this experiment in different fields of public healthcare, such as all the experiment is devoted to the computer vision solutions introduced in the public healthcare system in different modalities, MRI, mammography, radiology, computer tomography, mostly. And there is an operator of this experiment, the Unified Radiological Center, which is like governmentally driven, so this is the municipal body. And those companies which develop AI solution can participate in experiment and get a grant. The year amount of grants overall is about $2 million for all. And now we see that it's about 50 companies now participating in the experiment. And overall, their solutions have processed more than 10 million of results. And only during the 2022, almost 2 million of the results of these clinical testing. And the operator, every year, they make the so-called metrics of maturity of the AI solutions. So they have metrics on how accurate the diagnostic was, how this AI software was concrete in the diagnosis, and also they ask expert doctors in their particular fields to give feedback and compare the results of the diagnosis proposed by the AI technology and human-based. And after that, they make these quite complex metrics of the maturity of the proposed AI solutions, and they rank them, and they're like those which are considered to be mature and technologically reliable participate in the experiment for the next year, receive other grants, and so on. So this could be an example of this regulatory sandbox, because Moscow Healthcare Department introduces relative regulation to make that possible, to use the anonymized personal data of the patients, and to invite companies, developers to participate in such experiment. Thank you. Yeah.
Thank you very much also for sharing this very proactive approach that Russia is developing in terms of stimulating the use of AI and sandboxing, even also with funding for those who develop project, which is something not usual in sandboxes, but also quite interesting to see. Let's go now to India, and that has been developing a data protection framework for 6 years now, probably at the 5th iteration now. And so we look forward to know when the Indian government will adopt a new data protection law. I'm going to, you have a presentation, right? So I'm passing you the mic.
Thank you. Thank you. Thank you, Luca, and hi, everybody. Thank you for, I know they are competing sessions, so thank you for choosing our session and for giving us your time. So while the slides come up, what I'm going to do is just give you a very broad overview of some of the conversations we are having on AI governance. I wouldn't say regulation, because as you hear, we are not really thinking about serious regulation at this point of time in India. So an overview of data governance as well as AI governance conversations in India. And then I want to zoom in, because this term term AI is so broad and there are so many use cases and so many examples, it can get a little abstract when we keep talking about AI governance. So I wanted to zoom in on one particular use case. It's the application of facial processing in the airports management system. So I just want to talk a little bit about that case study and, use some of the questions around AI and governance, use that as a framing for some of the questions. Thank you. Next, please. So broadly, this is where we are in India in terms of the governance conversations right now. We've had a national AI strategy that came about by a government think tank called the Niti Aayog in 2018. That was followed by certain principles, and these are principles which are called responsible AI for all. I won't go into the details because for those of you who've been following AI governance conversations, broadly most of the principles we are seeing globally, whether at the national level or proposed by think tanks, etc., are similar in terms of what the principles, at least the high level principles, they talk about: transparency, security, privacy, a human-centric approach, etc. So the principles in India have been similar, and the document that followed the strategy and the principles, there was a kind of an operationalizing guideline. So how do we put these principles into practice? And the gist of that is, again, that it's not a regulation centric approach. When I say regulation, I mean formal regulation in terms of law. So it's not a law centric approach at this point of time. So the emphasis is more on thinking about self-governance, thinking about collaborative approaches. And this is all coming from the overall strategy in India, which at this point of time is about the promotion of AI. So as opposed to putting regulation, which in many quarters is seen as a roadblock to innovation. So instead of thinking about a regulatory approach, the approach right now is how do you set up centers of excellence where there are academic institutions, the government, private industry is collaborating to do innovation. How do you create these pools of data? So one of the thinkings that's coming from the Indian government is try to, how do you make data accessible? So of course, everybody wants the AI industry to flourish, but if you don't have readily available, cleaned, well-massaged, well-placed data to do that, then that innovation and thinking can't happen. So right now, the policy is around non-personal data because, of course, personal data, and I'll get into that in a moment, is much more difficult because there are many, many more concerns which come with personal data. But at least with the non-personal data, which the government holds in, across its many verticals and across ministries, if that data can be made accessible across the government and they say even to private industry, but only to startups within India. So it's very conscious decision to exclude the big tech, which already has a lot of data of its own from this process. But the thinking is to create a national data management office within the government where every government agency which collects non-personal data will pool data into this house, and then other agencies and departments within the government, when they want to do policy making, will be able to call for this collated, systematically created data in order to do AI applications on top of that. So that's the kind of thinking, and the government has clarified at this point in the parliament that we are not thinking about a discrete AI regulation, although there will be, as Luca said, we've been thinking in India for many, many years about a data protection law, and that's something which hasn't happened. And what I've been talking about and what I will describe in the next stage is that there is a lot of adoption. So there's a lot of digitization in India. There's a lot of, digital architectures being created. And so for researchers like myself, it's obviously a shock to think about how all of this is progressing without the framework of a data protection law. But that's where we are. We have a constitutional right to privacy, which was declared by the Supreme Court in 2017 in a landmark judgment. So that means that wherever the state is processing data, because fundamental rights are enforced against the state. So to that extent, there is now a protection. But of course, that means you have to go to a constitutional court and claim that right constitutionally. It's not something which is legislatively mandated. In the legislation, we have just one provision as of now in something known as the Information Technology Act. But there is this conversation going on about, and yesterday a new parliamentary session has started, and the news is that in this session, this bill will be introduced formally in the parliament, and we need to see. But the current draft which is out there is a digital data protection bill, and the idea is that it will cover all automated data processing and only digital data processing. So offline data which is not being processed in an automated manner is currently supposed to be out of the purview of this law, and it's a compared to, the data protection legislations, which you might already see across the world. It's a very light touch law, which has been proposed in the current iteration. And the idea is it again seems to prioritize business and allow business to flourish and not make regulation an impediment to, the way data processing takes place. And with that, I just want to get into the, deeper into one particular use case. So in the field of facial processing, again, we are seeing tremendous number of applications in India, both in the public sector and the private sector. And of course, the kind of justifications you hear about it are about enhancing security, it's about efficiency, it's about convenience. And in this particular use case, which is called Digi Yatra, so that translates into digital travel, that's a platform which was envisaged and thought about by the government as now being implemented in collaboration between the government and the private sector. And the idea, this is from the website, they describe it as a walk in the park experience at the airport check-in. So it is that you're able to use your face to do your boarding, to enter into the airport. So unlike airports in many parts of the world, due to security concerns in India, we have physical checking of your ID at the entry point of the airport, right? And you also know we are the most populous country in the world. So it is obviously very often a traffic jam at that entry point when people are trying to walk into the airport showing their ID card. And the developers of facial recognition technology saw that as an opportunity to, lure people into saying, here's a way we can make it really convenient. You will not be able to stand. You will not be required to stand in this really long line, and we'll make it really easy and efficient so that you just show your face to a machine and are able to go in. And the idea is that you will have a digital wallet on your phone where you will save your ID, map it with your digital identity, which we call Aadhaar, which is a biometric digital ID system. And then every time you want to go undertake a flight travel, you will say, okay, here is my boarding pass for this flight. And then at that entry gate of the airport, you'll show your face instead of showing your documents to a physical person and make that entry. And the idea is that in the end, this will become end-to-end. So from entry to the airport to check-in of the baggage to security, all of the processes will be through your facial recognition system and the biometric. Next, please. So here is a real, overview of what are the components of when we talk about a system like this. So right there, I've divided into 3 layers. There is obviously the project layer, which is an entity. It's a non-profit body called the Digi Yatra Foundation, which has been set up. Its constituents, the shareholders, are the Airports Authority of India and a number of airport operating agencies. And this is the entity at the operational level which will run the ecosystem. But the idea for this, of course, has come from the government itself. So it's the Ministry of the Civil Aviation, which owns this project, working very closely with the Niti Aayog, the government think tank I talked about. But there is also a lot of private think tanks, both technically and legally, who've been giving brain power to this idea and many other technical architectures that exist in India. And then in the middle of that, there is a technical layer where the government has been working with AWS. There is a cloud innovation center that's been set up in India, which is being used for the purpose of, hosting information around this. The government, working with AWS, selected an agency, a solution provider, which developed the whole technology behind this. And then, of course, because it's a wallet, there are devices involved. There is the app store involved through which, again, a series of terms and conditions, etc., come into play. So it's a fairly complicated ecosystem of factors. And just to clarify, this is all meant to be voluntary at this point of time. So this is being pilot tested in about 5-6 airports, and you have the ability to either go through the facial machines or to continue the old school way of, going through a manual check. And I want to just conclude with a few questions that this kind of an architecture throws up, right? So there is the question of, what is the legal basis of all of this, right? And I already told you we don't have a data protection law in India right now. We have some provisions in an existing law, but it's very well recognized both by the government, industry, and the private, the civil society, that it's not a sufficient framework, the one that exists right now. But the way this whole thing has come up is only through executive decisions. So it's through a policy document that the government has come up with and a privacy policy instrument, which this private entity called the Digi Yatra Foundation has come up with. So in terms of a concrete legal basis, either in terms of general law or in terms of specific law for this project, that's something which is lacking. There are privacy safeguards which have been thought about in the policy. So the idea is all your data is stored only on your mobile, in the wallet, which is on your mobile system. The the data which is transferred to the airport and to this foundation at the time of the transaction is not to be retained beyond 24 hours. But of course, as in every privacy policy, there are terms saying that, for the investigation of a crime, for assisting the government, for security purposes, there will be overrides and there will be access to data, which is possible. And just to remember that, because this is not flowing from a law, it is possible at any point of time for the entity to change its privacy policy or for the government to change its overarching policy so that 24 hours can become 72 hours, 72 months. That's really flexible because there is no legal safeguard behind this. And finally, on the question of accountability, although you can sense from what I'm saying that there is a problem in the fact that this is not backed by a legal framework, but at least in terms of transparency, what we've seen in this project is way more advanced than what we generally see in any kind of tech deployment in India. There have been rounds of discussions paper. These policies have been put out in the public domain. There has been analysis by this think tank, Niti Aayog, talking through, breaking down the steps of this policy. So it's actually more advanced than what we are used to, which of course is a low benchmark. But in terms of overall accountability, one question to think about it, as I said, that the fundamental right is enforced against the state. And in this case, this is a private entity which has been set up as a consortium. So that really raises the first question of whether it is clearly a state-like function, because today it's the central police force which enforces that entry at the gate. If you replace that with a technology which is operated by the private sector, there is the open question of whether you will still be able to say this violates my fundamental right to privacy, or does the way this has been structured override that possibility? And also more broadly, what are the kind of frameworks which will govern in terms of this entity, because it will not be covered by what we call the right to public information, the Right to Information Act, where you can call for information from public entities, etc. So there are a lot of frameworks which will be overridden by the fact that this is being operated privately and not by the government. And that's something which, escalates to broader technical ecosystems in India. This is just one example of that, but I will stop with that. Thank you.
Thank you very much, Smriti, for yet another very detailed presentation. And can you hear me? Yes. Yeah, something very interesting about India, which I think is not common to the it's common to very few other countries, honestly, not to other BRICS. And I honestly do not have another example of a country that has this multi-stakeholder approach, not only in the phase of the collection of inputs and feedback, but especially in the implementation, because all these projects are all implemented through either specific foundations or multi-stakeholder partners. Really well, the private sector works with the developers and geeks. It's maybe funded or simply promoted by the government, but it's really an example of, in terms of governance. We speak about it. We have another publication that is going to be published this year on digital transformations in the BRICS. And what is really interesting about India is the way in which they have, probably also because they have more stability in the government or the past 15 years, a lot of vision on how to have digital transformation, and they implement it through multi-stakeholder partnership. Multi-stakeholderism there is not only about having inputs through consultation to elaborate the law, but it's really about how to implement the vision of the government. Then we can debate whether the vision is correct or not, and we can exactly. We can debate whether the vision, there are of course criticism, but it's very interesting as a model. I see. We have started with almost 20 minutes of delay, so we can end with a little bit of delay so that we can have a little bit of debate at the end. And let's get into China and then South Africa. Yes.
Sorry. I want to control my time for a little because our lunch time is very invaluable.
Yes. Lunch time. Don't worry, I will.
I think it's over here.
It's here?
No. I think so.
Oh,
yes.
Excellent. So let me just share it. Right.
Okay, all good. Okay, thanks for the invitation, and it's a great pleasure to be here and listen to quite a few exciting topics. I hope that my topic will be super exciting as well. And I'm gonna share with you some very recent updates about the data and the AI governance model in China. Particularly, will give a very big picture of the very recent passed legislation or regulation on generative AI in China. So basically, we'll have a very, big global race to regulate artificial intelligence already. For example, we have the omnibus approach, like EU and Brazil. It's adopting a very comprehensive, act or bill to regulate artificial intelligence. There are also some pro-innovation perceptions, for example, in UK and the United States. And last month, I would say China is kind of a data protection approach to regulating artificial intelligence, because currently, after last week, the finalized, version of the generative AI regulation, was out. So I think it's a sort of like hybrid sectoral regulation model now. But it seems to us that from the legislator's perspective, everybody is considering the rising tension between AI strategic competence and AI accountability. The traditional tension between innovation and the regulation. So as you may know, that China has a long history of pro-innovation AI policy since 2017. The development plan for the next generation artificial intelligence, and it also has a sort of three-year action plan and some guidelines for the pilot AI zones as well. And if you look at the very recent 5 years plans, they consider AI as a strategic technology as well. But what's the rationale of those incentives? According to Li Kai-fu, Dr. Li Kai-fu is a sort of, China would like to be a sort of a Saudi Arabia of data to mobilize the social resources to get AI embedded into the digital transformation and such natural pool for training data. But I'm not sure if this approach works good or bad, well or not, but it seems in 2020, China tops the world in terms of citations. But China also has a sort of federalist issue. If you consider the top-down national common approach, and it has a central government, centralized planning approach, but it's also the localized provinces has different AI incentives. And if we also consider AI ethics in China, for example, in 2019, China created the Next Generation AI Governance Committee. And after that, it created a lot of the abstract, sort of the very high level guidelines for AI acts, and then some concrete ethical standards for AI as well. And then I'm confident that you're an expert of data governance in China, for China. So I will probably skip over this slide, but I'm just want to highlight the three laws: cybersecurity law, data security law, and PIPL. So for example, in the PIPL, there is an article about the gatekeeper for giant platforms in terms of transparency reporting. And in terms of automated decision making, we have the Article 24 and Article 55. Basically, those articles granted the platform users are sort of with the sort of the right to refusal or the right to option out. And in terms of facial recognition, particularly in the public areas, Article 27, did the job, but it has a sort of exception for public security. So this article mainly regulates private sector. And and also there was a case on the Zoom case, like the law professor would like to enter a Zoom in Hangzhou, but the Zoom used facial recognition equipment to scan they use the customer's face to grant their access, granted them access. But the law professor was super unhappy with this, and then he sued the Zoom immediately. And this case led the Supreme Court to release its judicial interpretation about facial recognition. So let's talk about the big picture of the generative AI regulation in China. After ChatGPT was introduced, actually, China is very good at catching up, as you may know. Internationally, Google, Meta, OpenAI are introducing their large language models, and in China, basically every big tech, even small techs, are introducing their own. Large language models is like, everybody. Yes. And then in April of this year, China released a sort of the draft for comment. It's a sort of measures for administration of generative AI services. I mean, in the very beginning, it talked about some, for example, data-related compliance, for example, those infringement of personal data and trade secrets. It also talked about IP issues, for example, the copyright using, I mean, infringing, I mean, others' copyrights, I mean, in terms of the training data. And it also introduced some articles relating to the content security, particularly the for example, disinformation or misinformation. But the last week, I think it's last week, yes. And I mean, CAC and some other, I mean, 6 other ministries released finalized the measures. But it's a kind of interim measures for the generative AI. Basically, according to its narrative, it would like to balance between development and security, to balance between innovation and the rule of law. But I mean, I think the most interesting part is that it would like to adopt a very similar, I mean, a mechanism similar to data security law. It would like to regulate generative AI in a manner of categorized and graded AI, I mean, approach. Okay, so, but before the art guy, I would call that generative AI measures. Actually, China regulated recommendation algorithms and deepfakes already. For example, according to the 2021's preventions on the management of algorithms and recommendation for internet information services, it regulates 5 types of algorithms, and then it also introduced a lot of compliance requirements. For example, the most interesting part is the algorithm registry. Basically, even you can find a very specific guideline for the how the those companies should do the registry. And then, but the finalized version of the RGI, basically, it regulates those services that use generative AI to provide the public within China with generated text, images, audio, video, and other content. Basically, it's a sort of content-based regulation. And then, if you want to know the characteristic for them, it adopted the precise regulation. Why it's precise? Because it includes the R&D of fundamental models. What is the fundamental models? You can refer to Article 2. And according to this fundamental model, I mean the conceptualization of fundamental models, it also adopted a model regulation. Basically, it would like to, I mean, adopt a layered regulation to distinguish between model and the services. You can refer to Article 7. And particularly, it defined what the model is. It means the generative AI technology are models and related technologies that have the ability to generate content such as text, images, audio, and video. And but if we compare the draft and the final version, basically it reduces the compliance burden. For example, it changes the definition of those big the rules of those big platforms from the content producer to information producers. There is a difference between content producers and the information producers. Typically in China, there is a lot of content regulations. So that means that this change made those big platforms do more compliance with the content regulation instead of data protection regulations. And then it has a specific article relating to training data. For example, it would like to ensure that the legitimacy of those data sources, IP issues, personal information, and it also has a linkage to the cybersecurity, data security, and the PIPO, and some other administrative regulations as well. So I think, yes, and it's also, there is a, China will, is currently considering to move into a comprehensive AI regulation model. I think that this, according to the State Council, and a draft AI law will be submitted to the NPC for review this year. So if it's adopted, I think it will be the first national, regulation covering AI. Okay, thank you.
Thank you very much for this way. Yet another very, very very exhaustive presentation in 10 minutes. So congratulations. A lot of regulations being adopted in China. It's very difficult for us. Actually, China is the most difficult country to follow in the BRICS, because literally every month there is a new regulation, especially at the end of the year in Christmas time, they release like 12. And so we have to update all our paper when you are ready to publish the paper or the book, and we have to work another 3 months to update everything. But it's very interesting. It's very interesting. I'm sure there will be questions, but before we get into the questions, let's see what happens in South Africa in terms of AI and data regulations.
Yep. Okay. All right. So I'm going to talk about AI specifically in South Africa, AI policy, or should I say regulation of AI in South Africa. We're not as advanced as in China. We are, however, developing policy and moving towards regulating AI legislation. Next slide. Okay, so I'm just going to briefly talk about two aspects of AI regulation in Africa, as well as AI regulation in South Africa. The emphasis, however, on this particular discussion will be on South Africa. And I've got some very, very, very interesting case studies that I'm going to be sharing with you. Next. Okay, so to start off our discussion, right? In South Africa, any legal discussion, be it family law, be it ICT law, be it property law, we always start with our constitution, right? Because the constitution is the supreme law of our country, for that reason, any academic discussion must always include the constitution. If you fail to cite the constitution in any academic discussion, you have already not achieved what you were intending to do. So when looking at our constitution and looking at international guidelines as well as norms, it has become quite clear that in terms of our constitution, we have certain rights such as the right to accountability, the right to privacy, as well as other rights in the constitution, such as non-discrimination, as well as equality and fairness. And these basically do rhyme with the international norms pertaining to AI currently, as well as freedom of expression. Okay, so South Africa does not have a specific piece of legislation. I'm going to put that out there right away, right? We don't have a specific piece of legislation. We don't have a bill at this particular stage on AI, but there are whispers, and I mean it, there are whispers of an AI bill that should be finding its way to Parliament, but next year is an election year. Therefore, the parliamentarians are busy with the elections. So I don't think we will be seeing any new AI legislation by the end of this year, most probably after the elections when the new government is in place. However, it does not mean that AI has not been regulated. You would have heard about the omnibus regulation or omnibus legislation in other countries. We've got the famous, or should I say the infamous, ECT Act, which is from 2002, a very ancient piece of legislation now. It used to be very new when I first started as a cyber lawyer. I think it's relatively ancient now. But the ECT Act does deal with automated decision-making in the e-commerce sense. And we also have the Protection of Personal Information Act, next slide, which deals with data protection, specifically the right not to be subjected to an automated decision-making process, right? And this right not to be subject to an automated decision-making process also has been, should I say, taken into several regulatory spaces. For instance, in the financial conduct sector, we now have certain regulations that deal with chatbots and how chatbots can interact with customers and how they can enter into financial services agreements using AI technology. So we do have certain regulatory measures that have been put in place there. Right. In addition to that, even our new Cybercrimes Act specifically deals also with cybercrimes that have been done using a computer, right? We are in 2023. I think it would be very, very backward for us to think when we're talking about a computer, we're not talking about AI as well. So we do also have certain, should I say, measures in our Cybercrimes Act dealing with the criminalization of automated programs that are doing criminal activities. Thanks. Yeah. So, as I said, I do have some interesting takeaways for you. I'm a case law man, right? I love case law. That is where the law is. I remember when I was studying law and I was struggling as a first-year student to parrot learn legislation. I was told that, you know what, you want to know the law, go and read cases. So I've brought two very, very fascinating cases that I'd like to share with you concerning lawyers and their misuse of AI and also the bench. The bench has also been found faulty in using AI. So in the first case, we have the case of Parker versus Forsyth. It had to do with a defamation case where a body corporate, so you know, in a sectoral property scheme, everyone does not get along, and someone said something defamatory about another party, and the lady sued the other party in the sectional title scheme. Now, what does sectional titles have to do with AI? Absolutely nothing. However, in the preparation of the defamation case, right, against the body corporate, the attorneys for the plaintiff were very, very, very naughty. They went and they used ChatGPT in looking for case law in supporting their defamation case. Now, I specifically have gone to specific paragraphs of the court to show you how the court was very, very dissatisfied with the use of AI. So what happened is the plaintiff's attorney went to court, they filed their heads of argument in support of their case, and as the presiding officer was going through the case law that had been presented, it appeared that, but wait a minute, this case law is not to be found in any law report, okay? And the presiding officer then went to the parties and said, look, I've searched through all the libraries. I've gone through Jutastat. I've gone through LexisNexis. I cannot find these cases. And the cases for the attorneys for the defendant also said, look, we've also gone through the law report. We simply cannot find these cases. And the case was postponed for 2 weeks to allow the plaintiff's case to go and find the cases that were cited. Now, we all know when you use AI, most probably the cases are fictitious and they don't exist. So when the matter then came to court again, the plaintiff's attorney was extremely embarrassed and had to confess to the court as an officer of the court to say that actually, my lord, we used ChatGPT when we were preparing our case. And I just want to cite specifically what the court had to say, some of the paragraphs. So the court in the judgment says the defendant's attorney were unable to access any of the cases or provide any of these cases, and neither was the plaintiff. And then the plaintiff's attorney, like I said, after the 2 weeks adjournment, they then confessed and they said, look, my lord, this is extremely embarrassing, my lord, but we also can't find these cases. And as a result thereof, the court in a groundbreaking regional court matter, so this was not even a high court matter, it was a lower court matter, the presiding officer went and looked at what exactly is ChatGPT? What does ChatGPT do? How does it source information? And how does it present information? So the court then went, as you can see in paragraph 86, explained that, look, ChatGPT is a form of artificial intelligence. It can produce essays for you. It can do all sorts of beautiful things for you. And in addition to that, the court then also went further and said, look, when lawyers do use artificial intelligence, they still have a duty towards the court to ensure that the sources that they find are actually in existence and that they're actually accurate, right? So that was the first slap that the attorneys got. Then the second slap that came, obviously now from the defendant's attorneys, they said, well, you guys have tried to mislead the court, right? And they made a request for a cost order for the attorneys to pay the costs to bonis propriis. In other words, the attorneys must pay the money out of their pockets by themselves. The magistrate, after having successfully embarrassed, and he uses those words in the judgment, after having successfully embarrassed the plaintiff's attorneys, declined to give a punitive cost order against the attorneys. And he said, well, this judgment should serve as an embarrassment enough for you guys. However, in terms of the plaintiff's case, as a result, was dismissed, unfortunately, because of this lack of proper research. And as a result, the plaintiff had to pay 60% of the defendant's legal cost. So there was a very, very punitive effect that came as a result of this. And the duty of good faith that we have as officers of the court was also put into question. Luckily for these attorneys, they did not refer the matter to the Law Society. And like I said, the presiding officer said, let this judgment be enough embarrassment for these attorneys. Now, if you thought that the attorneys are the only naughty ones, they're not the naughty ones. So in the case of, as you can see, the state versus Aliyu, so the state obviously is a criminal case. Mr. Aliyu was a Nigerian suspected drug dealer, and there was a request for his extradition to America. And at some stage during the deliberations, a submission was made that, look, there's actually an extradition treaty, and these are the requirements that you have to satisfy for this treaty. The bail application was granted for this person, and the state was completely outraged to say, well, how can you give bail to this person? And the matter then went to the High Court. And when the matter went to the High Court, the magistrate obviously has to give his reasons for his finding in the lower court. And one of the reasons that he gave is that he actually went and used Google. He literally used Google, right? And its abilities to search for cases and for legislation. And he used Google to rely on a treaty that actually doesn't exist. And as a result thereof, the bail application that was previously granted, it was set aside, and the High Court had some very harsh words for the presiding officer, and I'm just going to cite from those. It said, it is irregular for a magistrate to take cognizance what was uncovered on Google, and it does not bode well for the independence and the impartiality of the judiciary. So I'm going to leave you with that because time is short. I don't want to go further, but I would encourage you to go and look for these cases, and maybe you can write an interesting case note, and you can actually use this against your opponent one of these days as a comparative law case if one of your opponents is using generative AI. Thank you very much.
Thank you very much, Sizwe. As we have still, I mean, we should start, you should stop now, but as we started with 10 minutes delay, I would like to take a couple, I'm sure there are some comments or questions. So if we have comments, yes, okay. If we have comments or two, okay, I will take only two, because then you can reply and we can, it's very dangerous to be the one replying between the questions and lunch. So everyone be concise. Only two, okay.
Okay, thank you so much. My name is Ohara, and I would like to ask, how's the method to evaluation the market opportunities, especially in the facial recognition, and the risks for the human rights, especially for the Black people, and the situation of the public security. How to address the problem? The market, it's good, have a lot of money for these technologies, but the risk is so high to us. I would like to hear about these questions, please.
Okay, let's have also the second questions so that you can quickly pass the mic through there so that we can then have replies. Is there at the back? And maybe Smriti, you can start responding this because you have some.
Sure. Yeah. Thank you so much. My name is Grace. A very quick one on this issue of personal versus non-personal data. To the lawyers especially and technologists, like, is it actually possible, the bigger the data sets become, to separate personal and non-personal data? And very curious, especially India, which talks about it as if it's possible, how this is being done.
I'll take a first shot at these. Yeah. So on the facial recognition, like, it's a well-recognized, problematic area, that it's known that depending on the data set that's been used, et cetera, the results and the outcomes of these systems vary in the Indian context. Race is not as big as a factor as it is in some other parts of the world, but we do see other categories of discrimination based on caste, based on, scheduled tribes, based on just regional differences. A lot of people would see my face and say, you don't look Indian. So there is these, excesses of discrimination which are varied across different categories. One way in which it's being addressed is by using more diverse data sets, as researchers and civil society point out, okay, there are these problematic areas. The companies go and the governments go and try to improve their systems, but accuracy is only, we know, one of the necessary but not sufficient tools for using these tools. There are broader sets of problems. So that would be, and on Grace's question, my quick response would be, yeah, that is a pushback from, researchers and civil society in India, that it's not possible to demarcate, especially where we know that there is, easy re-identification. Anonymization is not perfect. So what could be a non-personal right now can easily become personal data again. And therefore, the idea of having two separate regulators, two separate regulatory regimes, becomes difficult and more and more difficult to enforce in that context.
Well, I think when it comes to the AI biases, I think the word is relatively straightforward, the biases of AI and how that effectively would be a form of discrimination. So I think one must move in terms of innovation and in terms of research to try and eliminate these AI biases in order to be compliant, for instance, with our law, not to effectively do forms of discrimination and to equally treat everybody. So I think that would be my answer to that one.
Yeah, just to briefly comment on that, I think it was yesterday I saw Nina saying that sometimes we need to include more Black people programming those machines, training that machines. It seems to be simple, right? Because we have our bias when we are doing that. So if we have data with quality, if we have the diversity on this programming phase, I think would be a way to solve that problem.
Yes, I will also like to add a bit to the first question. You might know Moscow is one of the most, a city with one of the most developed system of facial recognition, which of course makes it like more safer place. You feel safe almost every time, day and night in Moscow because of the security system introduced. But last year it turned out with such a more ugly face of this technology when it began being using to find people who participated in anti-war protests. So those who went to squares to protest against the violence, and then they were several hours or days detained in metro, in their workplace, because they were recognized through this facial recognition system, which is another example of not only bias based on, for example, race, but political position, which again signals that we need some search for balance between the public interests of security and our human rights in many the facets which we have.
Wait, do you want to say something else? Otherwise, we can wrap it. As you were speaking about ways of with face recognition, who better than Wei can lead about the ways?
Okay, yes, I think AI field is always technology related. So I think probably, I mean, in terms of legislative process, I think, I mean, those congressmen or should recruit a lot of technology experts in this side. For example, considering involved in the consultation process. I didn't. If you look at that, it's a lot of technology concepts. The models were certification or something like the very technology related. So I think probably, I mean, sometimes technology can, I mean, solve technology issues. Probably.
With this injection of optimism, I declare this panel closed, and I thank all the panelists for the excellent presentations, the excellent questions for the audience, and your patience for our delay. And now you really deserve very much this lunch downstairs. Thank you very much.